Now, somebody says that culture is more influential than law, and I want us to discuss, the effectiveness of law in achieving gender parity in light of the above statement. You see, the statement that culture is more influential than law captures a long-standing reality in gender relations. In many societies, including Kenya, culture often determines gender roles, culture determines access to power, culture determines inheritance, culture determines education, culture determines marriage, and even leadership. Now, law may prescribe equality, but culture frequently shapes actual behavior. Now, gender parity refers to equal representation, equal opportunities, and equal treatment between men and women in political, social, economic, and legal spheres. Now, the major question is whether law can effectively overcome deeply rooted cultural systems such as patriarchy. Now, the Constitution of Kenya 2010 is the principal legal framework for gender equality, particularly under Article 27, which is on equality and non-discrimination, Article 81B, which talks of the two-thirds gender rule, Article 56, which is on affirmative action for marginalized groups. So that Kenya's constitutional framework expressly guarantees equal treatment and affirmative action for women. Now, the discussion examines both the strength and limitations of law in achieving gender parity. First, I want us to analyze the relationship between culture and law. You see, culture consists of beliefs, it consists of traditions, it consists of customs and social practices. But law consists of formal rules which are usually enforced by the state. Now, the conflict emerges because culture preserves traditional gender roles, but law promotes equality. An example is traditional culture may say that a man is the head of the family. But you see, law says that women and men are equal. Hence, law often confronts culture. So, how does law, promote gender parity? First, law promotes gender parity through number one, constitutional equality. The Constitution of Kenya 2010 provides strong legal protections. Article 27 guarantees equality before the law. It guarantees equal protection. It also guarantees equal opportunities. Article 27(6), allows affirmative action. Article 81B establishes the two-thirds gender principle in Kenya. In fact, this is one of the strongest constitutional commitments to gender equality in Africa. Now, the Constitution of Kenya 2010 entrenched, the rule that not more than two-thirds of elective or appointive bodies may be of the same gender. So the effectiveness of this is that law creates formal equality, so that without legal protection, women will remain, structurally excluded. If you look at the case of Center for Rights Education and Awareness versus Attorney General, the facts of this particular case were that the petitioners challenged, Parliament's failure to implement the two-thirds gender principle. And the issue was whether Parliament had violated constitutional obligations. And the rule is that we have Article 27 and also Article 81B. So the application of this particular case was that the courts emphasized constitutional obligations towards gender representation, so that implementation of gender parity is mandatory according to the Constitution of Kenya 2010. So that the significance of this case is that law actively pushes for equality. Secondly, law promotes gender parity through reform of family law. You see, the Marriage Act 2014 and constitutional reforms have transformed, the rights of women, particularly in marriage. Historically, culture, subordinated wives. But modern law recognizes equality in marriages. If you look at the case of Rono versus Rono, the facts of this particular case concerned, inheritance dispute favoring sons over daughters. And the issue was whether daughters were entitled to equal inheritance. And the rule was about equality and non-discrimination. And so the courts rejected gender-based inheritance type of discrimination so that equal inheritance rights were upheld in this particular case. Now, the significance of this case is that law challenged patriarchal kind of customs. Thirdly, law promotes gender parity through political representation. You see, the Constitution of Kenya 2010 created, women representative seats. It created nomination opportunities, and it also created affirmative action. So that women's political participation has improved since 2010, but it remains below constitutional expectations. Analysts note that legal reforms increased access, but implementation gaps still persist in Kenya. Now, the effectiveness of this is that law increased, the visibility of women in politics, so that before 2010, women were extremely excluded. But after 2010, the representation of women actually improved. Now, I want us to analyze why culture remains more influential than law in Kenya. Now, the first reason why culture remains more influential than law is that patriarchy in Kenya still remains very strong. You see, patriarchy is cultural. It affects leadership, it affects inheritance, it affects marriage, and it also affects property ownership. So that even with law, many families still prefer sons over daughters, especially when it comes to matters of inheritance. And an example is, in land inheritance matters. So that culturally, sons are preferred, but legally, daughters are as equal as sons. You see, in practice, culture in Kenya often wins, and law has often lost, which is very sad. If you look at the case of Otieno versus Ougo, the facts of this particular case was that there was a burial dispute between a widow and the deceased clan, and the issue was whether custom governed burial. And the rule is that there is the recognition of customary law. And the application of this particular case was that the court upheld the Luo customary law. And the conclusion of this particular case was that custom actually prevailed. Now, the significance of this case is that culture, still remains very powerful in Kenya. Now, the second reason why culture remains more influential than law in Kenya is because of political violence against women. You see, women entering politics in Kenya face intimidation, they face violence, and they also face abuse. However, law protects political rights, but culture, discourages, the leadership of women, especially in the political space in Kenya. Now, reports continue to show that women candidates face harassment and violence, sometimes even more than men candidates. And this, undermine legal equality. So legal rights alone are not sufficient. The third reason why culture remains more influential than law in Kenya is because of harmful cultural practices. And I'm talking about practices like female genital mutilation, practices like child marriage, and also practices like widow inheritance. And you see, these ones, they persist in Kenya despite legal prohibition. And this clearly demonstrates, the resistance that the law is receiving from culture in Kenya. If you look at the case of AOO and 6 others versus Attorney General, the court upheld constitutional protection against harmful practices. Yet, social practices in Kenya still continues. You see, the law prohibits, but culture in Kenya sustains. Now, let's analyze the limit of law in achieving gender parity. Now, the first limit of law in achieving gender parity is number one, implementation gap. You see, a law on paper is not enough. Kenya's gender provision remain under-implemented. In fact, research shows that despite constitutional guarantees, practical progress remains slow because of political and social resistance. The second limit of law in achieving gender parity in Kenya is economic dependency. You see, law cannot instantly change economic inequality. Women still remain economically disadvantaged in Kenya. And so this means that economic dependence, limits practical freedom. The third limit of law in achieving gender parity is socialization. You see, from childhood, boys are taught leadership, but girls are taught, domestic roles. And the problem is that law does not immediately change, social types of conditioning. Now, I want us to analyze areas where law has been effective in Kenya. You see, the first area where law has been effective in Kenya is in education access. You see, law protects equal education rights. In fact, more girls now gain access to education in Kenya. And education is powerful because it weakens, patriarchy. The second area where law has been effective is in employment rights. The Constitution of Kenya 2010 prohibits workplace type of discrimination. In fact, women now have stronger labor rights than before. If you look at the case of the Federation of Women Lawyers FIDA Kenya versus Attorney General, the courts reinforced anti-discrimination principles and law improved, workplace equality. The third area where law has been effective is in judicial protection. You see, courts increasingly protect women's rights. So judicial activism in Kenya has strengthened gender equality. Now, I want us to carry out a critical analysis of the statement that culture is more influential than law in Kenya. You see, law and culture have always interacted, so that law is stronger in formal institution, but culture is stronger in day-to-day life. So that if you can analyze the difference now between law and culture, law creates rights, but culture shapes behavior. Law enforces equality, but culture preserves tradition. Law punishes discrimination, but culture normalizes patriarchy. Law enables reform, but culture resists reform. So that law, especially in Kenya, can change structures, but you see, culture changes attitudes. Now, gender parity in Kenya requires both. It requires, law, and it also requires culture. Now, let's look at the theoretical perspective of law in line with the view that culture is more influential than law. And the first theoretical perspective of law is the sociological school. Now, the sociological school argues that law reflects society, so that if society remains patriarchal, then law is going to struggle. Roscoe Pound's theory on social engineering suggests that law can gradually reshape society. Hence, law is a tool of transformation. Unfortunately, transformation usually is extremely slow. The conclusion is that the statement that culture is more influential than law is substantially true. You see, culture shapes lived gender relations more deeply than even law. However, law still remains very essential, so that without law, women are going to lack, enforceable rights, discrimination is going to be normalized, and political exclusion, especially in Kenya, is still going to continue. In fact, law has made significant progress in inheritance, in political participation, in education, and also in anti-discrimination. But full gender parity remains incomplete because culture still continues to resist legal reforms. Therefore, law is effective, but only partly effective where culture still remains resistant. So it's true that gender parity requires legal enforcement, it requires cultural transformation, it requires economic empowerment, and it also requires education. If it is your first time here, make sure to subscribe and to follow this channel for more legal lessons. My name is Biketi, and see you in the next one.